All right, so we're going. I'm going to get the PowerPoint fired up here on my other screen, and
Perfect.
we're going to get going. So everyone can see that, I hope.
Yes.
And we'll start as we always do with any sort of new things in the office going on. So one of the big developments, and for those who haven't met her, Mavish Megpool has joined us last August, I believe it was, and she's on the Zoom too, not presenting today, but watching. And she's been a wonderful addition to our firm. We've enjoyed having her immensely, and she's, the clients have enjoyed her company and work. So she'll be your primary contact for the client update meetings. She's really your go-to person going forward for, day-to-day kind of questions or scheduling your signings for updates and things of that nature. Of course, we work closely with her, and she's grown by leaps and bounds in less than the year she's been with us. So we're delighted to have her as part of our team, and I think you will be delighted to meet with her as well.
And just one thing to add about our team, as a reminder to everyone, we do have 3 incredible legal secretaries. So if you feel like it's hard to get a hold of any of us because we might be bouncing in and out of meetings, and you maybe just need a copy or a PDF of a document or something sent out or scheduling, you're welcome to talk to anyone in the department. Absolutely. So we encourage those communications. And admittedly, sometimes we're hard to get a hold of. So if it's really something administrative, you are welcome to speak to Lauren, Donna, or even Sarah.
Right, that's a great point. And because people often reach out to us, and as diligent as we are, we're very busy with meetings, as you know from your own experiences. When we do a meeting, we're in a conference room, we're not answering calls and doing emails. So if you need if you have a funding question, Sarah's your go-to person. If it's a Medicaid question, it's going to be Lauren, and Donna handles most of the estate settlement work. But they can all help out as necessary, and even just get the message to one of us so we can take care of it. So never hesitate. We're a very cohesive group, and we can do anything together collectively better than any one individual.
Right.
One thing I didn't include in this, we have changed. I'm trying to think when we did it. We switched over to a new practice management program called LEAP, LEAP. Ironically, just like Action Step was that we used previously, it's an Australian-based company, or maybe Action Step was New Zealand. I don't know. Some reason down under there, they're very proficient at creating law practice management software. So this is a cloud-based program, and their portal system, which is called Law Connect, is really terrific for sharing documents. Much easier and less involved than Action Step was. So we've been using that for a number of months, and it incorporates all of our practice management and accounting features. So that's really all I'll share about that today. If you have any questions, we can help you with that. So we're going to move. We do have a few document updates, as we typically do in a given year. So I'll let Megan take care of some of this discussion.
Sure. So as always, we're trying to improve your documents as we go, and every year we give you the opportunity to make changes that you want to make based on changes in your life or your relationships and things like that. But we're also trying to stay on top of the latest language and technology and things like that as well. So, and I think we just lost the screen there. Perfect.
Sorry.
No, that's okay. So one of the things that is now more easily available to us is something called a right of occupancy provision. That's actually, we've been crafting these provisions for a long time, and many of you have something like this in your documents already. But what we have now available to us is sort of a standard provision, a standard template that we can work off of, so that when you do request a language like this, it's very simple for us to add into your document. So what is this right of occupancy provision? It's where in your trust typically, but it can be included in a will as well. It gives one of your beneficiaries the right to remain in a particular piece of real property. It's normally your primary residence, but doesn't have to be. And it can be for a certain period of time or for their lifetime. provision. So if you want to really make sure that they have use of that property even after you're gone, you want to make sure that no one can kick them out, you might include or consider including a right of occupancy provision. So we have software that we typically use to start to assemble some of our documents, and then we customize it further from there. Nice thing is that this software now includes a very simple version of this right of occupancy provision, and then we customize it for your and your beneficiaries' needs. So we just are giving a few examples. Sometimes the provision is really useful in a second marriage situation for a surviving spouse, or maybe even for an adult child who's not necessarily financially independent. And again, you want to make sure that they have a place to live. You want to secure that for them. And we can do it for a term of years if that seems to make sense for your beneficiary in your situation, or we can guarantee it for their lifetime. And there's lots of additional provisions that really we would discuss with you to make sure that expenses of the home are paid and things of that nature. So we can really customize this to fit your beneficiary's needs.
Yeah. One thing I was remiss to include, and I should have, is just talk about firm information for a moment. To toot our own horn a little bit, I just want to pass on that recently I was again named to the super lawyer list for elder law in New York State, which is limited to the top 5% attorneys in a particular discipline. And I was further honored by being named one of the top 25 attorneys in the Hudson Valley across all disciplines. So certainly nice to get that kind of affirmation. And these are supposedly objective determinations by other, through other lawyers and other criteria. I don't know exactly how they come across this, but Super Lawyers is an independent company. And Megan was named a rising star for Super Lawyers, which is even more exclusive. That's only 2.5% of all attorneys under the age of 40. So we like to think we're pretty good at what we do, but it's nice to get third-party affirmation of that. So we strive to do better every day, and we're continually working towards that goal. So anyway, after enough about us, we'll go back to the documents. So Megan, talk about the Santa Claus a little bit.
Oh, so this is sort of a fun name for something that can be a really sticky problem for people. Every year thank you for the congratulatory messages in the chat box, by the way.
Oh, that's right. Megan's a partner in the firm. How did I forget that? Yes. Effective March 1st, she became a partner. So lots of
old
good
news by now, huh?
It is. It's old news. I forgot about it.
Thank you. Every year we give you an update on the estate tax exemption levels, and we're gonna give you the update this year as well. And every year we kind of say, this is what the numbers are, and most people are not facing any kind of estate tax, so that's typically not the priority in doing estate planning. But some of our clients, and certainly some people throughout the country, are facing some estate tax, and they are nearing that exemption level. So for those people who are close and slightly above the estate tax exemption, particularly for New York State, which is the lower of the two exemptions, although still quite high, you would be facing a little bit of a sticky situation known as the estate tax cliff. And this is just applicable to New York, not for the federal estate tax, but for New York, there's an estate tax cliff that says that if your estate is over the exemption level, which this year you'll see that updated number there, 6.11 million, by more than 5%, then the estate tax exemption is essentially phased out. So they have this weird 5% window, and then anything over that, your exemption is phased out. It's gone for you. So the practical effect of the cliff is that for New York State estate that is greater than the exemption amount, but not greater than 105% of the exemption amount, so you're somewhere in that 5% window, the estate is going to be subject to an estate tax that's greater than the amount that would be due if there was no exemption. So you're kind of getting whacked here if you're falling in this cliff, this window. But we think that we have a nice solution for it, and we've started including including some provisions to address this problem in pretty much all of definitely our revocable trust documents, and then certainly wherever applicable. So we like to include provisions that can address a problem, even if you're not currently facing the problem. So you'll see this here. But first we have an example. So in the example, Alex dies on April 1st of this year, poor guy, with a taxable estate of 6.16 million, which is only 50,000 more than the exemption level for this year. All right, so he's only 50,000 above. And because of the cliff, his estate would owe $126,480, which ends up being 253% for the amount above the exemption. So for a 50,000 overage, now he's paying, or his estate is paying over $100,000 worth of tax, which really stinks. So the solution here is, luckily, Alex did some planning with us in this example, and his living trust includes the Santa Clause that we've begun including in our documents. And the Santa Clause provides that if his taxable estate is in that cliff range, that percentage that we're talking about, then the trustee is authorized to make a charitable gift that will reduce the taxable estate to the exempt amount. So we're going to kind of lop off the overage. We're going to donate that to charity. And who doesn't like to make a nice donation to charity, especially when it's going to benefit them as well. And that way we're bringing his estate back down to the exemption level, and we're reducing or even eliminating, in his case, for the taxes owed. So for Alex's trust, the $50,000 amount in excess of the exemption level will be distributed to a charity, thereby resulting in no New York estate tax. So rather than pay over $100,000 in estate tax that would be owed without the Santa Clause, the charity receives $50,000, and now the family saves, they're able to preserve the remaining, that $76,480.
Right.
So really nice benefit to both parties, the decedent's family and also to a charity.
Right. So keep in mind, this clause only applies when you're in that weird, you're just over the exemption, but by less than 5%. Because once you go over by 5%, the Santa Clause would have no benefit. You'd pay the same estate tax regardless. So it's just a weird, result in New York law that we thought would be fixed by now, but they haven't done it. And so by using this clause, we get to solve this problem, as Megan alluded to. And on the next slide, we just have the language that is included in the documents today, the trusts, et cetera, this is the Santa Clause. I mean, you should have all received the slides. And if you haven't, we'll get them to you, or you can look on the recording, but I'm not going to read the whole thing. So that's the Santa Clause. And then we have a HIPAA update. HIPAA, as you may recall, is the federal healthcare privacy law that's been in effect technically since 1996, but the regulations didn't become effective until the early 2000s. But we've been using a standalone HIPAA authorization for probably about 15 years now. And the new rules, the new regulations that have come out allows for a termination of a HIPAA authorization for up to 50 years after the principal death. Prior to that, it had been 2 years. So if you would like to have your HIPAA extended well beyond your death, if a family member needed to get your medical records, for genetic information or otherwise, you want to have your HIPAA last, up to 50 years, which is practically forever, because that will, the privacy rules expire under the current laws 50 years after your death. So that's something we can certainly go ahead and incorporate in your documents if you wish that information to be readily available to your agents and other family members, which are typically going to be your HIPAA agents, and that's usually your spouse and your adult children. So Megan, why don't you tell us about our new power of attorney form?
Sure. So we had the new power of attorney form go into effect about halfway through last year. So for those of you who updated after June 13th of last year, you would have already received signed off on the new HIPAA form. We've already begun implementing this, and we started talking about it last year as well. But just as a reminder, the new HIPAA form, then it's a statutory form, so each state has their own version. This is New York's new one. Eliminated the requirement for a separate gift writer. And that was the second half of the form that made it a little bit more cumbersome to get through. That form is one that feels like it takes forever when we're signing it. So many places to initial and 2 places to sign in the old form and things like that. So the new form really squishes those gifting powers right into the main part of the form. It's not really 2 separate forms anymore, which is nice. It makes it easier to get through. Additionally, a person who has any difficulty signing their name, and this is really considering maybe it's a physical difficulty, we still need to make sure that they have capacity, they understand what it is that they're signing, but someone who has a difficulty signing their name can actually direct another person to sign on their behalf. So this is really useful for people with certain kinds of disabilities that make signing documents very, very difficult and even stressful for them, because a lot of times people know that they'll have this difficulty and they'll try their darndest, but they're still not happy with how that signature comes out. So now we have this option available, which is really, really nice. The form does require a notary and 2 witnesses, and one of those witnesses can be the notary. So the formalities of it, it's not going to feel much different than in the past, because in our prior powers of attorney for signing the gifts rider, we still had these same requirements. We still needed the 2 witnesses, and in the main part of the form, it needed to be notarized. So it'll still be the same number of people in the room, but here it's nice because, and I think Rich, this was an update that you just sent in a seminar that you attended. It's nice because now we have this notary and 2 witnesses, which is compliant with a lot of other states' requirements for powers of attorney as well, such as Florida. So we're keeping up with that signature requirement there, but really it shouldn't feel much different to you. An agent's authority to make gifts to him or herself. So reminder, the agent is the person that you're appointing to assist you with your financial transactions under the document. They have the authority to make gifts to themselves if you grant it to them. And those provisions are included in the modification section now, where before all the gifting powers were in the separate statutory gifts rider. And just as a reminder, gifting powers are really, really important when it comes to Medicaid planning. So a lot of times people will get to the gifting provision and we'll talk about it and they'll say, well, when are my agents going to be making gifts? I'm not really sure that I'm comfortable with this. But as we talk about it, it becomes apparent that gifts are uncompensated transfers, and that becomes very, very important to preserve assets should you down the road need to qualify for Medicaid, and we still want to protect what you have in your name.
Right, and in a little bit, we'll talk about some of the updates in the Medicaid rules going forward.
So then we also have available to us something called a disposition of remains form. We've had this form for a little while, but I think it just really wasn't used as frequently. So we want to bring this to your attention and let you know that this is available to you. So the New York Public Health Law authorizes use of a form to appoint an agent to control the disposition of your remains. So this is obviously different than your healthcare documents. This is after you've passed away, you're designating a person who is in charge of disposing of your remains. And as long as you have been able to convey your wishes either orally or on the form, they should do that in accordance with whatever your wishes are. The form, like I said, can include specific instructions for disposition. So it can be burial versus cremation. But if you have something in more detail that you'd like to describe, you're welcome to do that on the form there. And also in most of your binders, you should have a memorial instruction form where you can elaborate even further. But this document, this disposition of remains, this is a legally binding document for your agent. At your option, go ahead.
I was going to say, and this can be especially important in blended family situations, I would think, where, you know, your spouse is not the parent of your child, for example, and maybe there's some conflict or potential conflict between them about what one party thinks should be done with you or to you versus what the other party says. And if you don't have this form, it could be a bit of a free-for-all. And
Mhm.
so we, Mavish has prepared, you, based on the statutory form, a questionnaire that we're going to send out to all of you when you register for your sign up for your individual signing meeting. And you can indicate on that form any of the information that Megan was just talking about, any specific instructions. There's also a place to indicate if you have a pre-need funeral arrangement in place with a particular funeral home. And
Mhm.
it's not a mandatory document. If you don't care to do it, you don't have to, but we're making it available for all the clients so that you can have more specificity about your disposition wishes.
Because I think, and Rich, correct me if I'm wrong or if you know, but I think under statutory law, if you don't have something in writing, it just goes to next of kin and they'll have to
Yes.
demonstrate, that how they're related to you. So there is a hierarchy already in place under statutory law, but certainly having some instruction is better. So.
It's very analogous to the healthcare proxy, where if you don't have one, then there's the Family Healthcare Decisions Act comes into play, where again, if you're married, your spouse has first priority and then your kids, but there's no order of priority among the children. Let's say
Right.
same thing here. Let's say you're not married and have 4 kids,
Mhm.
and you die without this disposition remains form, and the kids have a disagreement. It could get a little ugly about what happens, and you could be sitting there and hold like Lenin or something like this for 10 years, right? No one wants that.
Exactly.
So that covers the document updates, and we do have some, I think, useful and important things this year. We'll now switch over to the legislative and regulatory update that we do each year at this point. So let's talk about some of the new laws. So as Megan mentioned earlier, as we always do, the estate tax exemptions continue to increase because they are tied to inflation. So the federal exemption increased from 11.7 million in 2021 to a little over 12 million this year. For married couple, of course, that means over 24 million of assets can pass free of any federal estate tax. And the gift tax exemption is tied to that. So if you've made, for example, $2 million of lifetime gifts above your annual exemption amount that we'll get to in a minute, that would reduce your at death exemption to just $10,060,000. So as you can recognize, very few estates today are paying federal estate tax. As Megan also mentioned, the New York State exemption is now 6.11 million, which increased from 5,930,000 last year. And again, we still don't have a separate gift tax. But if you make large gifts within 3 years of your death, those large gifts, meaning above the estate tax or the gift tax exemption amount, will be brought back into your estate for determining the value of your estate. The annual gift tax exemption, which of course, a lot of people still think it's $10,000. That's what when it first sort of came into play years ago. And now because of inflation, it went from 15,000 in 2021 to 16,000 this year. So you can give $16,000 of any kind of property, cash, stocks, real estate, whatever it is, to as many individuals, don't have to be related, as you like in the calendar year, without filing any paperwork. And just to refresh what that means, if you give more than 16,000, let's say you buy a car for 32,000 for your child and you paid for all the money, 16,000 of that technically counts as your towards your annual exemption. The other 16,000 would reduce your remaining federal estate gift tax exemption for lifetime exemption from $1,260 to $12,046,000, or $44,000 rather, if my math is correct. And of course, if you're married and you gave the $32,000 car to the kids, each of you can use your individual exemption, so there's no filing required of any kind. So that's the update on those numbers.
And just one comment on gifting. Just be careful with gifting, right? We're saying that you can do this, but these are the rules for taxes, for Medicaid, and for those of you who have done Medicaid planning with us, don't make gifts, especially sizable gifts, without maybe running it past us first.
That is correct, because there will be implications really perhaps from $1 of any gifts for Medicaid purposes.
Right.
Speaking of Medicaid, we do have some interesting changes ahead, and we thought there'd even be more interesting changes, but that did not come to pass. So just in the recently passed budget of a week or so ago, prior to the passage of the budget, Governor Hochul had requested that the legislature, in fact, eliminate all resource tests for Medicaid services for long-term care, both institutional and at home Medicaid. So what that would have meant is that you have $1 million sitting in a bank account, you could get Medicaid in the nursing home from day one, which would have been quite a radical departure from where we've been for all these years. At the end of the day, the legislature, while it improved an increase in the community Medicaid income limit beginning January 1st of next year to $1,563 per month from the current $934 a month, so we have a bigger cushion of income, it did not approve the repeal of the resource test. However, based on the way they're going to calculate it going forward, the resource test, which right now is $16,800, will be increased. We don't know the exact number, it'll be something a little bit more than $28,000 next year, which will help because a lot of times when we're doing our Medicaid applications, we're dealing with these pesky small cash value life insurance policies, which can be sometimes difficult to deal with. And now by having a little more cushion, we don't have to worry about necessarily transferring some of those kind of things out of the person's name to give them a little bit more of a resource for additional needs when you're in a nursing home or even in your home setting and you need to, buy a new wheelchair or whatever it is. Always better to have 28,000 versus 16.8 in the bank. But we still have to engage in our crisis planning techniques to get people to these levels without fully draining all their assets. As many of you know already, and you have your Medicaid Asset Protection Trust, part of the objective of that was to get the assets, a portion of your assets, primarily residences and other real estate and some liquid assets, out of your name for countable Medicaid purposes. Start that 5-year look back when it's transferred to the trust. And if you're past the 5 years, those assets don't count against your eligibility. So we'll keep an eye on what happens in the years going forward about the resource test, but for now it's still in place. Similarly, we have there has been, and they're still on the books technically, going back now 2 years ago, a phased in 30-month look back period for community Medicaid services, where there was supposed to be, and there was still supposed to be, a retroactive date of October 1 of 2020, when non-exempt transfers would be subject to a Medicaid penalty for community Medicaid services. As you may recall, or may not know, so I'll refresh that piece. Currently, for community Medicaid services, there are no asset transfer penalties. You could have $600,000 in a bank account that can be transferred to your child today, April 21st, 2022, and effective May 1st, in 9 days, you would be eligible for community Medicaid services from that point forward. There's no penalty imposed as there would be for a nursing home case. As part of the then Governor Cuomo's Medicaid redesign team in 2020, there was a proposal to try to save money, taxpayer money, to make it more difficult to qualify for community Medicaid services. But essentially what happened just at the time this was put into the hopper, COVID hit us, and we all know what that's done. And so that has been delayed. The implementation of this scenario has been delayed. And frankly, because of concerns at the New York State Department of Health about how to implement it in the community Medicaid context, it is very likely, we believe, that this will never go into effect. If it does go into effect, it won't be effective until at least October 1st of this year. So we'll be sure to keep you apprised as to when or if any new changes in the community Medicaid rules go into effect, and we'll probably send an email blast should that transpire. So we have one more legislative piece to talk about. This relates to the Secure Act, which was enacted in 2020, January of 2020. And it's taken now over 2 years for the US Treasury to issue proposed regulations that give a little meat to the bone of what the Secure Act put in place pertaining to retirement account type assets. So just about 2 months ago now, the Treasury issued their proposed regulations. And while they're still going through public comment period, more likely than not, these will go in effect pretty much as the Treasury has proposed. So what are some of these regulations? Well, there has been some confusion over the 10-year payout period that a non-spouse beneficiary must withdraw from a qualified retirement account after the death of the original owner. The biggest change in the Secure Act from a asset withdrawal perspective was that prior to Secure Act, you may recall, a non-spouse beneficiary could use their own life expectancy for taking out distributions from the inherited IRA after typically the parent's death. So if a 45-year-old inherited an IRA, they may have a 40-year window with which to withdraw it. In the earlier years, of course, the smaller withdrawals, meaning less income tax. Fast forward to the Secure Act implementation. Now that 45-year-old beneficiary is going to have to take all the IRA assets out within 10 years. So by the time they're 55, the IRA will be pulled out. And of course, unless it's a Roth IRA, they're going to be paying income tax in bigger chunks on those withdrawals. There was a question whether you could, as the beneficiary, wait till year 10 to take it all out. So you get 9 years of deferral and just a big tax bill in year 10, or you had to take out in somewhat equal installments during that 10-year period. What the proposed regulations will say, and if they're implemented, would impose is that if the original owner died before their required beginning date, which currently is age 72, the beneficiary could wait until year 10 and take it all out in that year. However, if the IRA owner was over 72 or 72 or over and was already taking their required distributions during their lifetime, the beneficiary has to take it in each of the 10 years, a distribution each of the 10 years after the account owner's death. So that would be depending on the death of the original owner about how much and when you have to take it out as a non-spouse beneficiary. Just as a reminder, spousal beneficiaries still can do spousal rollovers to become the new owner of the account and then use their own life expectancy, defer taking till age 72. So that has not changed at all. One thing that is helpful, we from our perspective as estate planning attorneys, is that the proposed regulations will make naming a trust as a beneficiary simplified to ensure that the beneficiaries of the trust can retain the protections that the trust structure affords, and yet take out the distributions over the longest possible period. If the regs are going into effect, we no longer will have to worry about what we've had to currently make sure that the oldest trust beneficiary is an individual beneficiary, for example, and not a charity. That will sort of go out the window. We won't have to worry about so much who those beneficiaries are, and who the successor beneficiaries are named will no longer affect the distributions over the course of the 10-year period. Because if your trust doesn't qualify, and this is a term of art, designated beneficiary under the Internal Revenue Code, you can't use the 10-year period. You have to take it out in 5 years, which is of course even worse from an income tax perspective. So we have lots of savings law clauses in our trust language to ensure we get the maximum payout. This will make it even easier to qualify as a designated beneficiary. So I think that covers our legislative discussion. There's a question about, even though there's with a Roth IRA, there is no tax liability to the beneficiary, which is true. It says, how is the inheritance of a Roth handled for the beneficiary? Well, the beneficiary still has to take out the distribution from the Roth within the 10-year window, whether it's payable to them or to a trust for their benefit. That has not changed. The distribution, of course, will not be taxable income, but when the money comes out, it will no longer grow tax deferred or tax free. And then the beneficiary takes that money, they'll invest it somewhere. Presumably it'll be, unless you buy muni bonds or something like that, that will then become a taxable asset in terms of the income produced from it. So Roths are great in that respect, of course. They're tax-free withdrawals to the beneficiary, but you can't keep it in a Roth beyond the life of the original Roth owner for more than 10 years as a general proposition. So hopefully that answers your question. So now we're going to shift over to some, as we like to talk about every year, there's always some interesting estate planning and elder law cases, and this year is no exception. Megan found some great cases, and I'll let her start with the first one for us here. So This is a local one right here in Orange County, matter of Cardelli.
Yeah, this one was interesting, and I was happy to find one that was local for us too. So in this case, an individual passed away with assets that were valued at less than $30,000 in his name. So what this means is when you have assets in your name, right, individually owned, no joint owner, no beneficiary. So this takes you back to some of those estate planning basics. If the amount values at less than $30,000, you can do something called a small estate proceeding, or also known as a voluntary administration. So in this case, that's what his relatives pursued. So they filed a small estate in the surrogate court in Orange County here. And in this case, the petitioners were sort of looking for some information. They wanted a little bit more information other than what's been filed in the surrogates court. So here they were alleging that there were potentially millions of dollars in assets that could have and should have been part of the estate, except for that this decedent was smart and they did some estate planning that involved a trust. So the reason that there was less than the $30,000 in his name is because not only did he set up the trust, but he also funded it. So most of the assets were titled either to the trust, or maybe they used some beneficiary designations. And really that only left very few assets in his name alone at the time he passed away. So this is the goal. When we're doing the planning with you guys, we hope that everything is connected, everything is funded. And that way we really don't have too much in the way of probate assets. And that way we can really avoid or minimize any kind of court involvement. And this is the reason. So now we have some nosy people saying, hey, wait a second, where's all the money? There should be more money in this estate. I want to see where it is, right? So like we said, this is a small estate proceeding. And what that means is that in a small estate, the person who's submitting the small estate is not seeking admission of any kind of will. They're just saying, you know, there's very minimal assets here. Let's go with this simplified proceeding. So no admission of a will for probate here. And so here, no party was seeking probate at all. That's an important point for this finding. So what the petitioners are looking for is some discovery. They're looking for information that is authorized under a probate proceeding, which would allow them to discern the nature and whereabout of non-probate assets. So they're asking the court to give them a glimpse into where these things are. They want some paperwork. They want to see transactions. Here, the court held that the petitioners are permitted to perform what's known as pre-objection examinations and discovery. And it's important. They were asking for pre-objection examinations and discovery. The examination and discovery part is I'm seeking information. I want some paperwork, but they're also concerned that they're going to trigger what's known as a no contest clause in the trust or in the will. All of you have no contest clauses in your documents, and those are to make someone a little bit fearful about contesting your document, attacking the document, because they risk losing any potential inheritance if they trigger this no contest clause and they lose the contest. So the court says, don't worry about that. normally we can give you these pre-objection examinations and discovery without triggering a no contest clause. That's not your issue here. What the court says is that the right to such pre-objection examination, so the right to this paperwork, requires the actual pendency of a probate proceeding in the first place. And because this is a small estate and there's no probate proceeding actually on the table, the court says, we're not giving you the right to look through this documentation. You're not doing the pre-objection examinations, and you're not getting any discovery pursuant to this statute because no probate proceeding is on the table here. So the court actually dismissed this petition. And this just goes to show that really, if we can make sure that everything is funded correctly, right? Because the legal document itself, the trust itself, is not enough. We really need to make sure that your funding is right. And if that's the case, then should you even face a small estate situation after you pass away, it still gives you a layer of protection. It still makes sure that those looky-loos aren't able to just jump right in and start digging through your personal business. So this was a nice result. It goes to show that probate avoidance is worth it in a lot of cases. That's not to say that the petitioners here don't have other recourse, other actions that they could try to pursue. It's just that in this instance, they didn't choose the right path.
It is more difficult for them. The less information they have up front, the harder it is for them to know what to do next, right? And the lawyers are not going to be as interested in taking on a case like this if they don't feel comfortable that there's going to be a good result for them. And the small estate threshold in New York is now, and for the last few years, is $50,000. So, you know, through our funding process that you've all gone through, it's highly unlikely that any of you will have probate assets exceeding 50,000. It's typically just like a tax refund from the IRS that is made payable to Mr. John Smith. And the IRS doesn't care that you have a living trust. If they send a refund, it's going to go to the individual. So we may just have a small estate cleanup, and that's why we have pour over wills and all that stuff. But this would help keep the, as Megan alluded to, the nosy other relatives or disinherited child to keep out of your business as much as possible, and to make it very difficult for them to bring any cognizable claim against your estate or trust. So I'll take the next case, which also a very interesting legal case. Estate of Greenberg versus Montefiore New Rochelle Hospital from March of this year just came out. It's a first department case, which is, for us people up here, we call it downstate, out of Westchester. So here, a very interesting situation. In 2011, a gentleman, Mr. Greenberg, did a standard healthcare proxy with his wife named as the healthcare agent, and a living will, as many of you have, that says treatment to be limited to measures to keep Mr. Greenberg comfortable and relieve pain if his condition became incurable or irreversible with no reasonable expectation of recovery. Pretty standard living will language that virtually everyone has who has a living will. So fast forward 5 years, he had to go to the hospital in New Rochelle at Montefiore, and he brought with him, or his wife brought with her, copies of his healthcare proxy and living will. His wife, as authorized under the healthcare proxy, presumably completed what is known as a MOLST form, which is a more detailed medical directive signed by the client or their representative and the physician, which gives very specific instructions about what treatments to include and what not to include. And if you're curious about a MOLST form, you can go on the Department of Health website, Google New York State MOLST, and you'll see what the form looks like. So notwithstanding the MOLST and the healthcare document and the living will, the hospital and the treating physicians gave Mr. Greenberg life-sustaining treatments until he died a little bit more than a month after he was admitted to the hospital. Mrs. Greenberg was upset about this because clearly the hospitals, or at least seemingly, didn't comply with his wishes, her husband's wishes. So she filed a medical malpractice action saying that the medical care they provided was in fact malpractice because it did not, the defendants departed from the standard of care by providing him with treatment that was against his wishes. And patients are allowed to have treatments or not treatments as they wish. And the claim in the lawsuit was that Mr. Greenberg suffered pain and suffering for over a month that was unnecessary. And the facts showed that the doctor, upon his admission at the hospital, confirmed his healthcare directives and they understood what they were. And despite the express wishes that was known to the hospital and the physicians, another physician, in fact, ordered these additional treatments that were not necessary to alleviate Mr. Greenberg's pain. And therefore, he lived for 30 more days than he probably otherwise would have. The hospital and the physicians who were sued in this lawsuit tried to have the action dismissed, relying on a case called Cronin versus Jamaica Hospital, which had held that a claim for wrongful life was not permitted under New York law. The Supreme Court, the trial court in this case in New York, actually said, okay, yeah, we agree this is the same rationale as in the Cronin case, and we dismissed the lawsuit. So Mrs. Greenberg filed an appeal, and the Court of Appeals in this case, in fact, reversed the lower court order, holding that unlike Cronin, which was a claim of wrongful life, this case, the Greenberg case, was simply a medical malpractice claim, and therefore she was allowed, Mrs. Greenberg was allowed to continue her lawsuit at the trial court and prove that the hospital did or did not commit legal malpractice and the physicians therein. So it's a pretty important case in a lot of ways, in that it should put hospitals and physicians on notice that these healthcare directors that we have, and pretty much I'm sure all of us have them now, we're on this Zoom, are to be taken literally and with serious reflection and adherence to the provisions in those. So it's not just words on a page. You follow these directions, and or there may be some legal consequences. So I think this is a good and useful opinion that we can all bank on. And we have one more case to discuss. So Megan will take us through another, I think, terrific case, Petitioner versus Silver.
Sure. So in this case, a wife, Virginia, brought a proceeding against her husband's agent. Now, that agent was appointed under a power of attorney. So all of you have powers of attorney, and you'll probably be updating yours this year. So we thought that this information was really, really interesting because this could apply to anyone. And we want you to be very careful about choosing your agents and really consider your family members' dynamics as well. So she brought a case against the agent under the power of attorney, seeking to have the agent file an accounting. So she wants him to account for any transactions that he performed as agent, and also to have the agent removed as attorney, in fact. Virginia's husband, Morris Silver, had appointed his cousin Harris to serve as his agent rather than Virginia. So in reading the facts of this case, it does seem like maybe this was a second marriage situation, or at the very least, it's known that in this case, husband and wife typically kept their finances separate, which makes sense that Morris appointed his cousin rather than maybe his wife in this case. So this is an interesting backstory a little bit, which created this tension. Virginia and Harris got into a dispute regarding Morris's preferred living arrangements. And I should note, by the time this case, or even before the case, by the time the tension started bubbling up, Morris was starting to need additional care at home. So he was becoming disabled, which is why he was relying on Harris to manage his finances for him. And it seemed like he needed some additional medical assistance as well. So Virginia wasn't happy with how Harris was managing the living arrangements for Morris and how certain expenses were being handled. And the case gave a couple of examples. One, that Harris engaged in certain actions that led to the purchase of an apartment falling through. And notably, they lost their down payment on that apartment. So there was some loss of funds here because of his actions. And also, Harris withdrew $1.3 million from Morris's IRA. So there are large transactions going on here. Clearly, the parties to this action are of substantial means. And it's interesting that the 1.3 million was withdrawn. I don't know the size of the IRA as a whole, or what these funds were applied towards. But so now Virginia's saying, hey, wait a second, I'm thinking something's going on here. I'm not happy with how things are going. With regard to the accounting, the court held that the spouse can bring a proceeding, even though she's not an agent, she's not appointed as a fiduciary anywhere, just by virtue of being a spouse. She can bring a proceeding to seek what's known as approval of receipts, disbursements, and transactions. So not exactly an accounting, but kind of reviewing some of the transactions and the records, any of those actions engaged in by the agent. But this does not include the right to receive all manner of documents. So it's just sort of a limited review of the transactions and actions that the agent has taken. So she does have standing to do this. The court further held, though, that Virginia hadn't met her burden of proof to compel the court to require the approval of the transactions at issue. The court noted that there was no concern expressed by the wife that her husband was not receiving the care that he needed, and that there was no allegation that the agent was engaging in self-dealing. So she simply applied to the court for the ability to take a look at these transactions, but she didn't really express, I guess, in good enough terms for the court's criteria, why she was looking into this. And even the examples she gave, I guess, didn't meet the standard for the court to say, you know, let's take a deeper look. So the court held that Mrs. Silver's curiosity was not a sufficient reason to make the court oversee these expenditures. And they said, in quotes, simply because petitioner disagrees with certain actions does not mean this court should insert itself into the familial dispute. It is undisputed that the respondent is acting under a broad power of attorney that is not subject to any limitations. Under these circumstances, the court declines to intervene without some actual showing of wrongdoing. On these papers, petitioner only offers speculation and innuendo about supposed malfeasance. So here the court said, absolutely not. We're not having the agent turn over any records. We're not going to review the transactions. Here the agent was entitled to take actions that he believed to be in Mr. Silver's best interest, and therefore the motion to dismiss the wife's petition was granted. The court said, we're not giving you the relief that you're seeking here. So very, very interesting facts to this case. And I wouldn't say, obviously, that this is going to arise in most people's situation. We have a lot of assets at play, and we have someone who's not the spouse serving as the agent, which is a little bit unusual. So here the court said, we're not getting involved. This is a family dispute, and you really haven't demonstrated to us that the agent's doing anything wrong. You maybe even agree that your husband is being taken care of. It's just not the way that you would have done it. And so we're not getting involved here.
So my assumption is that Harris Silver, the agent, drove up to the court in his Hyundai rather than his brand new Rolls Royce at that time.
Exactly.
Personally, if I'm the judge, I would probably inquire a little bit about this $1.3 million IRA withdrawal.
Yeah.
That does seem a little peculiar, so I don't know. Maybe Mrs. Silver would have to reformulate or hire a private investigator or something, because that's the only way. It does seem a bit odd, but it does show you the power. We all have these powers of attorney, and you do too, of course. And when you designate your agents, you got to make sure that the agent is the right person, and maybe there was a very good reason to take the withdrawal of the IRA. I mean, there could have been, maybe it was for Medicaid planning. Who the heck knows? The facts don't tell us, and there doesn't seem to be any indication showing what happened to that money. Right. So very interesting, but it does show you how powerful our powers of attorney are, and the agent does have broad authority. However, they do have a fiduciary obligation and cannot steal money. If it is shown, if she can find that he stole money, he's going to be in big trouble. But that doesn't, that the facts don't show us that. So as we have done for the last number of years, our last sort of part of the conversation today is what we call our planning spotlight. We always try to pick a different focused topic that maybe we haven't talked about in a while, or haven't really gone into any great detail, that is part of all of our planning circumstances. So this year we decided to talk about special needs trusts and special needs planning. And everyone on the Zoom has at least a contingent special needs trust within, whether it's your living trust or your pour over wills. We have them all in here. We're going to talk about why that's important, even if there is no one in your life today who has a special needs situation. So a little background. Presently, there are approximately 43 million people who are classified as disabled. who have either physical, mental, or emotional needs that need to be addressed. Some of these folks may need professional care, supervision, or lifetime parenting or guardians. And by the term, the meaning of definition, the definition of disability, I should say, is a condition that is expected to last at least 12 months and that seriously interferes with ability to work or conduct activities of daily living. So we have all these people, 43+ million in this country, but there are hurdles that are out there that impact on the ability for the people to receive the proper care that they need. Part of it is that many professional advisors don't have the adequate experience in dealing with special needs circumstance. They don't know the laws and the resources available. And then another hurdle is the failure to accommodate changes in the morphing or changing of benefit programs such as Medicaid, SSI, and the like. And of course, economic conditions can change that can impact on the family wealth and other circumstances that might apply to the beneficiary or the disabled person in this case. Other hurdles are the failure within the estate plan to provide adequate written instructions for the care and well-being of the disabled person. Procrastination in any life is any walk of life is of course an issue. Not doing legal documents that will provide adequately for your disabled loved one can be a big problem. Some of the other hurdles include some of the unrealistic expectations of the ability of the child with special needs. Sometimes the parent is overly optimistic about the development of that child. I'm using parent-child as the most common relationship, or they are overly pessimistic that the child will be less capable than it turns out they're able to be in adulthood. Certainly relying on other family members to take care of the disabled child when you're gone. Sometimes that is readily available and they're able and willing to do it. And sometimes even with the best of intentions, because of the other complications in your other family members' lives, can make it difficult, if not impossible, for them to step up to the plate when needed. And certainly there's some always uncertainty about the continued availability and benefits through various public benefit programs that exist. So some of the dangers that our special needs family have to deal with includes changes in the child's situation, changes in federal and state law, and of course, changes in the client's situation, where they live, where their disabled beneficiaries living, financially, etc. So when we talk about benefit programs, and these will be very much implicated in the type of estate planning issues that we're talking about, we have what we call need-based benefits. So we'll get into some of those. Non-need-based benefits, anything that regardless of your wealth you can qualify for. And then some are sort of a hybrid that they're available to everyone, but if you have ability to pay, you have to contribute for some of the cost. So a traditional needs-based benefit are your Medicaid and SSI programs. So SSI, which is for disabled beneficiaries who don't have any work history, because people who have a work history of at least 40 quarters of work, you qualify for SSDI, which is not a needs-based program, but Social Security income. So people with lifetime disabilities are going to get a certain dollar amount, but there are very strict rules under the federal law, and this has been for many years. If you have more than $2,000 in a bank account or other investment account in your name, you're ineligible for SSI. So it's a very low threshold. Some of these rules vary from state to state. Different states could have different income requirements for Medicaid and SSI. And so we talked about your eligibility would be based on your income and your available resources. So needs-based programs are deemed to be programs for the needy and truly destitute, and programs of a last resort. And you have to be pretty poor to be eligible for these programs. So for example, New York, the maximum SSI income that you can have before reduction of your benefit is only $794 a month. If you have more than that, you'll reduce your benefit until, if you reach a certain level of income, probably about double, you get no benefit at all. Process for application takes 2 to 4 months typically. Most payments will not go directly to a minor. They have to go to a designated payee. And I talked about the $2,000 resource limit, very low. That's for SSI. Medicaid, as we talked about earlier, to qualify, you can have $16,800. So you can qualify in the community for Medicaid coverage, but not be eligible for SSI. But once you're eligible for SSI, you're automatically eligible for Medicaid. Some of the non-need-based programs, Social Security and Medicare, obviously, you qualify regardless of your wealth or income. Of course, the more income you have, that will change your copay requirement and that possibly taxation of your Social Security benefits. But you're still eligible regardless of what you have. Certain programs are non-need based, but they do bring an element of need. The Earned Income Credit and the Child Tax Credit are programs that have a financial test. What is not relevant in any of these determinations is what the cost of the actual child's care is not a consideration. You know, I've had clients who have very severely disabled children, you know, wheelchair bound, cannot speak, etc. They require a 24/7 aid. That will not impact on your eligibility. And then we have your ability to pay programs. You qualify regardless of financial status, I should say, but what you might contribute are charged back to the payee based upon your ability to pay. So if you have a child in a residential group home, you may have some contribution requirement there, but they'll still be eligible regardless of your net worth. And Medicaid has some ability to pay if you have income above a certain income, the income limit, currently $934, for example, for community Medicaid, and you have $2,000 a month of income, you might have to kick in about $1,100 of your income. Of course, we do have pooled income trusts as an option, but the general concept is if you're over the income limit, you have to pay something. So with all those background elements in mind, let's talk a few minutes about how we do the planning for special needs. One of the fundamental no-nos in any estate planning is do not leave assets directly to a special needs beneficiary. Once they inherit those assets, if it's over the exemption levels, and for SSI it's over $2,000, they will lose their needs-based benefits, which could be very damaging for their situation. So the best way to do it, of course, is to use a properly designed and funded trust to preserve the beneficiary's benefits. So of course, you are all much more familiar with trust than you were before working with us. So we're going to talk about this in some detail here. So most of us have the traditional support trust, which says my trustee shall provide to the beneficiary for their education, health, welfare, and support, or words to that effect. And in most of our cases, our children are their own trustees, certainly once they're over an age, often 25. So that type of trust is great for creditor protection, divorce protection, bloodline protection, things of that. But language in that trust will probably result in their ineligibility for government benefits should they become incapacitated or disabled under the definition of disability and apply for government benefits. These types of trusts are great for our non-disabled beneficiaries, as I described. So instead of a support trust, what is necessary for our disabled beneficiaries is a discretionary or special needs trust. So a supplemental needs trust is designed to supplement but not supplant or replace public assistance benefits. The viability of supplemental needs trusts was first was not a statutory rule initially, and this goes back to, I think it's 1993. There was a case called Matter of Escher that went up to the New York State Court of Appeals, where the Court of Appeals ruled that a supplemental needs trust or discretionary trust was a viable planning tool to allow a beneficiary to have trust assets, but not have them lose their public benefits. The Escher case was essentially incorporated statutorily in the Estate Powers and Trust Law in New York, Section 7-1.12. So any well-drafted will, revocable trust, or irrevocable trust that leaves assets in a general support trust for a beneficiary, which, as you know, that's what your trust has, will include, or should certainly include, what's called a trigger provision that will convert our standard support trust into a discretionary supplemental needs trust if your beneficiary should ever become a person with special needs. So one of the beautiful things about giving these standard support trusts that we typically all have is that even if at the time of your death and your kids inherit your assets, they're perfectly great and fine and so on and so forth, if a year or 10 or 20 years down the road, they have a disabling condition, under the terms of our legal instruments, our legal trusts and trust documents, the support trust that they've used for all these years until the event of disability, by virtue of the conversion language or the triggering language, will convert their trust into a supplemental needs trust. So if there's $1 million in it, that trust will not count against their eligibility should they wish to or need to apply for government benefits. So the triggering language we all have is listed on this slide, which says, if under any provision of this trust, my trustee is directed to distribute to or for the benefit of any beneficiary, when that person is receiving or applying for needs-based government benefits, my trustee shall retain and administer the trust property as follows. And then it goes on for like 7 pages of special needs trust language that incorporates the statutory provisions. Now, one thing that would certainly change beyond just the nature of the trust is your beneficiary will no longer be a trustee. Either they will have to appoint someone new, or the trust advisor through our law firm would appoint a new trustee if there isn't a default successor name. So there's plenty of flexibility to make all that happen. So this slide will just show you the structure of what this supplemental needs trust will look like. So the supplemental needs trust is created by a third party, usually a parent, grandparent, or sibling. We're not going to get into the other type of supplemental needs trust, which is a first party trust that would be created by and with the assets of the disabled person that they already have. This is a third party trust, which is even a more protective trust, is created and funded by a third party. So in our legal instruments, our living trust, whether they're revocable or irrevocable, you have these third party trigger trusts created. So they're going to be funded with typically the parent's money. And if it is created during lifetime of the parent, which sometimes is the case, but most often is part of your testamentary disposition. But if it's created during lifetime, transferring those assets to the trust will trigger the gift tax rules. So if you give $100,000 into a lifetime trust for a disabled beneficiary, you would have to file a federal gift tax return, and that $100,000 would come off of your $12+ million exemption. But practically speaking, it won't cause any issues. You put assets into the trust, and it can be funded via a will or living trust upon the death of the parent. This is also great use for life insurance, that if you're really uncertain about how much your disabled beneficiary may need, and you're concerned that the resources you may be leaving to them will be inadequate, and you want to provide for your other non-disabled beneficiaries, buying a good life insurance policy specifically targeted to this S&T could be a great idea. The trustee can be you if it's funded during your lifetime, or some third party. It just cannot be the disabled beneficiary. The trust can specify that income and/or principal may be distributed to or for the benefit of the beneficiary to supplement but not replace or supplant government assistance. Has to have language to that effect. And then after the death of the beneficiary, if they have children, it can go to them. It can go to your other children or grandchildren or any other heirs that you specify. And of course, it would typically be left in some kind of protective trust, because that's just how we roll through our practice here. So we all have this lurking in the bowels of our trust instruments. And if you have a currently disabled beneficiary, which some of you do, they will already have built into our trust, or your trust, a specific supplemental needs trust. It's not a trigger, it's there already. But this is great for our non-disabled, currently non-disabled beneficiaries, because it can spring into life at any time during their life expectancy or their lifetime. So that covers us for today. I guessed it was about an hour and 15 minutes, and we're about right on the money for that. Pretty good guess. We've had a few questions today. So going forward, again, you should know the routine. You'll reach out to us. Mavis should be your first contact to set up your, I don't know, how are we doing? Is Donna reaching out to the folks? Is that what happens? I'm trying to remember the process.
So some of you would have received your worksheets already, but for anyone who hasn't yet, Lauren has gone through the list of attendees today. She's prepared your worksheets and you'll be receiving those in the mail. So as always, fill them out, send them back to us. And then at that point, just give us a call, or once we get your worksheets, we'll give you a call if you haven't reached out already, to schedule that one-on-one update meeting. And like Rich said, the one-on-one meeting will typically be with May. For many of you though, I'll still be popping in to say hello, and certainly to help with witnessing and notarization. Sometimes you need a whole team behind you, right? So yes, if you get the worksheets and you want to give us a call just to hurry up and get on the calendar, that's fine. Otherwise, when you send them back into us, we will reach out to you.
And we will also send you with the worksheet this year, we'll send that disposition of remains questionnaire. So if you want to include that form as part of your document set, we'll send that, return that with your review worksheet. And then we'll create the form when you come in to sign with May and or Megan, you'll get that and that'll be added to your portfolio. So hopefully, I like to think that this, again, shows the value of this maintenance program. I think there's a lot of new stuff out there, and nothing stays the same in estate planning for sure. So we thank you for joining us today. Spring weather is here and coming, and hopefully good health and better days ahead for everyone. So thank you for joining us again. And again, this is recorded, so it'll be on our website soon if you want to hear something new or refresh your memory. And we look forward to seeing you in the office. So thanks again for attending, and have a wonderful day. Bye-bye.